All rise. Superior Court of Monterey County is now in session. The Honorable Thomas Wills presiding. Please be seated. Morning.
We're on the record in so-called measure C cases, essentially B cases in which Chevron versus County of Monterey and Aera Energy versus County. Council state appearances on the record, please.
Good morning, Your Honor. Theodore J. Bush Jr., representing Chevron and the Ardo in the matter that ends in 397.
Good morning. I'm sure you need the
Good morning, Your Honor. Andrew Bassett for Aera Energy.
Good morning, Your Honor. Matt Klein on behalf of CRC in 790.
Good morning.
Good morning, Your Honor. Woodward and Brown on behalf of Eagle Petroleum in the case ending 935.
Good morning.
Good morning, Your Honor. Edward Renwick, Lieutenant Martin, appearing for the payroll and the various mineral owners, and that's the case number. We got it here today. Case number CD 17 CD 000871.
Good morning, Your Honor. Jeffrey Ditzer on behalf of the Chevron plaintiffs in the case ending 9-7.
Good morning, Your Honor. David Balch for the trio plaintiffs in the case ending 1012.
Good morning.
Good morning, Your Honor. Denise Kahn, representing Monterey County, Dr. Laura Solario.
Good morning.
Good morning, Your Honor. Gene Tanaka on behalf of the County of Monterey in all cases.
Good morning.
Good morning, Your Honor. Sean Haggerty on behalf of the County of Monterey.
Good morning.
Good morning, Your Honor. Robert Shawn on behalf of Monterey County in all cases.
Good morning, Your Honor. Colin Preston on behalf of interveners in all cases.
Good morning, Your Honor. Lucas Musker, Robbins Kaplan, on behalf of interveners in all cases.
Good morning, Your Honor. Jackie Sisky on behalf of the Aera.
Good morning, Your Honor. Savannah Fletcher on behalf of Protect Monterey County Interveners.
Good morning.
Good morning, Your Honor. Peter Broderick on behalf of the interveners in all cases.
Good morning. Okay, today we're going to commence the trial of Phase 1 of the Measure Z cases. The issues to be addressed at this stage of Phase 1 are whether all or part of Measure Z is preempted by federal law under the Safe Drinking Water Act and the EPA regulations and regulatory actions thereunder. Whether it's preempted by the authority given to the State of California Department of Gas and Geothermal Resources in its role for the State of California of primacy in administering the federal law, or preempted by the California Public Resources Code independent of federal law. Related to those issues, a preliminary question of standing which we'll address in a moment. Also, on the board for today, whether any portion or portions of Measure Z are, if any portions of Measure Z are invalid, is the balance of the measure severable, and it remains law. And closely related to the first two areas, the legal interpretation of Measure Z's provisions. The court has reviewed voluminous materials about 2 feet thick and submitted by the parties. Measures which include not only the parties' comprehensive opening, proposing and reply briefs, but also deeds, property, mineral rights, declarations from geologists and petroleum engineers, materials from the Environmental Protection Agency, State of California Department of Gas and Geothermal Resources, and State Water Resources Control Board, declarations from former officials of the State Department of Gas and Geothermal Resources, ballot measure materials, photos of campaign materials and news clips, which is not to say that all of the above are admissible. We do want to remind the parties and council, and I'm sure you will follow the rules. This is a court of law, not a political forum. All comments should be confined to issues of law. On the issues of standing, I received some papers in the file this morning, over the weekend. Preliminarily, I want to note that I think standing has been established by the plans. One exception, which will involve a factual determination, and that is standing to challenge segment 1 of Measure Z, the well stimulation treatment provision. As I understand it, the plaintiff's position is that because of ambiguity regarding the wetland, the Department of Gas and Geothermal Resources threshold levels for the use of acid in well treatment and maintenance apply under Measure Z. That petitioners therefore have standing to challenge that segment of Measure Z. For petitioners, is there any other basis for standing to challenge the well stimulation treatment portion of Measure Z that's asserted by any of the plans? Mr. Maurice?
Yes, thank you, Your Honor. We believe that we have multiple grounds for standing, including the one that the court just identified regarding acid maintenance and stimulation. The standards for standing in California are very broad. The Holmes case from the California Supreme Court, excuse me, California Court of Appeal, for example, says that the plaintiff just has to demonstrate that the statute could have the effect of infringing their rights. And here, as the court knows, the Chevron, for example, was one of the main targets of Measure Z. It's almost like it's a bill of attainder. And with the court's permission, I'd like to put the screen down and show you. And I think the court's already probably seen this, but here, this is a continuous connection. The Measure Z itself, the findings say that well stimulation and hydraulic fracturing is likely to occur in the county of Monterey. Chevron's not using those methods right now at San Ardo Field, but this is a measure that directly targeted Chevron. I'd like to show slide 71. And again, it's a very broad standing. That's one of the photographs I believe the court was probably referring to. And we have signs, Chevron, and there was other campaign efforts against a particular company for this measure.
Well, getting into questions of admissibility.
Certainly. Even without considering the ballot material or campaign material, it's just from the text of Measure Z itself and its findings, it's very clear that Measure Z was aimed at Chevron and other oil operators and other companies. And therefore, under the broad principles of standing, it's clear this measure could have an effect on Chevron over and above the well acid maintenance. It may decide that somewhere else in Monterey County, the Measure Z talks about the Monterey shale and says the reason that this is being passed is so that companies like Chevron and others won't engage in well stimulation, which, as I'll talk about momentarily, is explicitly authorized by Senate Bill 4. Under for purposes of standing, that's all that's required, that you're in the zone of interest that the measure was aimed at. Clearly, Chevron and the other companies are in that zone, even if they're not at this moment engaging in that precise activity. So I think under that theory, Your Honor, we would have easily have standing. And as I said, the principles in California are just very broad. broad, much broader than Article 3 standing in the federal courts. There's even taxpayer standing in California. So the possibility that Chevron might in the future use well stimulation or may need to or may decide to, that's enough for standing purposes. And then we get to the merits, which we're going to launch into later this morning.
Yes, Your Honor. I'm going to be very brief today. I'm mostly going to be joining Mr. Boutros' arguments on the preemption issues. But in terms of campaign materials like that and standing to challenge Measure Z, I would ask the court to take a look at footnote 5 of the Senate versus Jones case. And that's 21 Cal 4th at 1151 footnote 5. And what the California Supreme Court did in that case, and that was a case where the single subject matter rule challenge was made of the sort that we've made in this case. The California Supreme Court took judicial notice of a newspaper article in which the proponent of the initiative discussed his strategy and means of getting a ballot measure passed. And what he did there is he said that to people in parking lots to get signatures on petitions, hey, this ballot measure is going to cap legislative salaries. And another part of the ballot measure was affected the way that voting districts were set up. And he admitted in that newspaper article that he used the cap on legislative salaries as an inducement to get voters both to put the initiative on the ballot and then ultimately to enact it. And the California Supreme Court itself, in that footnote 5, the Jones opinion, found that to be part of the misleading campaign that gave rise to the single subject matter claim in that case, and they struck down that statute in 1999. If you look at the earlier Bresnahan case that's cited repeatedly by interveners and the county, in that case, Chief Justice Byrd, albeit in her dissent, includes in the text of the Cal 3rd Reporter, if you have a copy of the Cal 3rd Reporter in your chambers, there's a big political card stand that's included in the text there. And in the majority opinion, the court cites newspaper, radio, and television editorials as part of the extensive public debate that it was willing to consider. So 2 points, Your Honor. Number one, in our single subject matter claim, we definitely have standing to challenge their use of the fracking ban as the kind of signature centerpiece of the campaign, number one. So there is standing to get into that part of Measure Z. And number two, it absolutely is relevant evidence to go beyond the text, as the California Supreme Court has twice indicated and held in reaching the ruling that it reached in Jones. And so we would submit that standing is appropriate here across the board without qualification.
Your Honor, very quickly, David Walsh, the trio plaintiffs, and just a reminder on standing that there's also the public interest exception, and it's discussed at length in Save the Plastic Bag versus City of Manhattan Beach, 52 Cal 4th, 155. And the pinpoint is 165 to 67 and 170. And in that case basically held that when you have a case that is dealing with broad and long-term environmental effects and the enforcement of a public duty, and in this case it would be the enforcement of the Public Resources Code to lead this to the state, and the plaintiffs show an interest in those laws being followed, there's an exception to the standing requirement. And it's public interest exception, it's the fallback. But in any event, all plaintiffs, we believe, have shown standing on all issues. Even if there was one issue that the court were to disagree on, then the public interest exception would come in to fill that gap and provide standing nonetheless. And that's a very extensive analysis from the California Supreme Court, Your Honor. Thank you.
So you're saying that there's standing as to multiple issues, even though there might not be as to one. In fact, that there's standing as to the other issues, confirmed standing as to the one that's in this meeting.
No, the public interest exception, Your Honor, would say if there were issues that the court would determine that there was not standing on, that would not bar the claim anyway under that long-held exception. And I believe Mr. Boutros was talking about the relaxed standing requirements in California, and that is one of the hallmarks of the standing requirements was the courts want to see these issues litigated on the merits, and so they created that exception as a fallback. And I did not want the court to overlook that. Thank you, Your Honor.
Your Honor, Edward S. Randall, just very, very briefly, I'd like to point out in line of what's already been said, that the prohibition, land use prohibition of LU 1.21 prohibits any techniques that increases the permeability of the formation. We've been talking a lot about hydrofracturing, and of course, nobody's using hydrofracturing at the moment, and probably maybe never again in the county of Monterey. But if Measure Z is around for any length of time, the oil and gas business is driven technologically, and we don't know what techniques will be developed in the future, and there may be a technique coming down the road that will increase the permeability of formations. That's perfectly acceptable.
But isn't it wiser to wait until that issue is ripe for adjudication instead of speculating now as to whether or not you might drop it wrong?
You mean we have to have another lawsuit to decide whether new technology can be used, or perhaps a prohibition on increasing the permeability of the formation is going to stifle creativity and stifle the technological process? I think there's a huge public interest argument involved here, Your Honor. I mean, we ought not to be passing regulations saying you can't go out there and develop new technologies, and this, in effect, does that.
Thank you.
Plaintiffs are included on the comments. Your Honor, 2 points. It's perhaps a matter of semantics, but I think this question needs to wait until Your Honor decides how to interpret Measure Z.
That's where we're headed, at least insofar as what if, excuse me for interrupting, but I agree, if that portion of the ordinance can be said by interpreting it as requiring or incorporating the Department of Gas and Geothermal Resources threshold levels, then that portion of standing backwards, it seems to be, unless because of a broader definition of standing that have been raised by counsel here this morning comes into play.
Your Honor, I've always thought that maybe it's just a matter of how you terminate it as a mootness question. If there is an interpretation of Measure Z such that it does not affect their operations with respect to well stimulation treatment, then I think the issue is moot at this point for them. It's not right. I'm not challenging standing, but that's sort of how I look at it. I think that's why it needs to reach your decision. Second point, the narrow plaintiffs are quite numerous in number. We have always stipulated that we are not going to challenge their standing for this phase because we don't want to put them through the exercise of showing each of the many plaintiffs have standing. So that's why we've entered into that agreement. We stipulated in court, and we stipulated with the plaintiffs in a written document for the recent file. I don't want to put them through that. I don't think it's necessary, but I just want that reserved such that because that might come up later. Thank you.
Can we talk a little bit about how that might arise? Do you have some specific scenario in mind?
What I don't want to do is go through the exercise of deciding all these little issues and then have somebody say, well, I don't have standing for this.
I have nothing to indicate to me that any of those plaintiffs in the narrow case lack standing. However, it's quite possible we have parties that are named erroneously or the deeds don't apply, and we didn't want to get into that in phase one.
Thank you. Ms. Gunn?
I believe the court knows that the intervener's position is that it's premature and speculative to determine standing at this phase. There's been no discovery allowed, and we have objected on various grounds to the admissibility of most of the evidence that's been submitted. Additionally, we haven't had an opportunity to brief We received a couple of briefs last night around 10 o'clock. To the extent the court is relying on those, we'd like an opportunity to respond. But primarily, we believe it's not necessary and it is premature for the court to decide standing at this point in the proceedings.
Well, you know, there was a lot of evidence, by petitioners. And the court feels is relevant to the issue of standing. And in light of those materials, and many of them are just deeds, mineral rights deeds, that those are clearly relevant to standing, and I frankly don't see how much more there would be in dispute.
Well,
It's a bad understanding. The question in the court's mind is really as to the low stimulation treatment portion of it. All of the evidence has been submitted is that there is no fracking going on in Orradre. None of the petitioners or plaintiffs engaged in fracking. The only evidence I recall seeing is that one company tried fracking about 2 years ago and then abandoned it. So that issue of mootness or standing looms out. And so I'm going to take another look at the public interest exceptions. Quoted language about whether the legislation could have an effect on claims or the business owner interest cited broadens that area a bit, changes the picture for standing to raise these challenges. But it seems to me that in the articulated basis that I've seen in the briefs, and I've read it, I just got some of these this morning, but the articulated basis in the briefs that I've seen from plaintiffs and petitioners is that because of the acid well stimulation definition and inclusion in segment 1, so-called anti-fracking portion, that they have standing because the Department of Gas and Geothermal Resources has already set threshold levels that distinguish when the use of acid is in low stimulation treatment as opposed to simply being low maintenance. I think that portion can be saved by interpretation. So whether that raises questions of preemption because it's duplicative of existing state regulation and state regulation under authority from the Environmental Protection Agency is another issue. That's a preemption issue, but we don't get to that if the people who are raising the claims. So,
again, would it be possible, I'd like a chance to read it as well, Your Honor, before the court reaches a conclusion. Also, can I clarify whether the court's preliminary finding on standing is limited to this one?
well, it changes phase 2, obviously. In what sense, yes, it is. There are ancillary questions that need to be answered if you get into taking as applied analysis. And that's going to vary from petition to petition. For regulatory taking, we do have materials that have been submitted that indicate standing, at least one petitioner to raise that, whether other petitioners have a right or not. I think he's going to answer a factual determination. But there are many steps we have to go through yet. But I appreciate the fact that, for instance, in a takings as applied challenge, can't even make that kind of standing determination this point, and it's not an issue.
Your Honor, might I suggest that we can begin that, say by the end of the day Wednesday, we each file a short submission targeted on your comment about standing to address the fracking point, and we'll exchange it. And we're working on some service issues, and we'll do that with them and make sure that we get it to you by the end of the day Wednesday.
Now we can define short.
5 pages is fine for us.
Don't feel compelled to fill up 5 pages.
Maybe we'll do 2.
Say it in 2.
Great, thank you.
Okay. Now.
Your Honor, I'm so sorry. Before we start, again, I want to confirm how the procedure you followed for objections. You've lodged a lot of objections. I've asked the plaintiffs to I've asked the plaintiffs to stipulate and the county that our failure to reiterate these objections during these proceedings isn't a waiver.
No, you've all voiced your objections. I've gone through all of the objections. I've reached some tentative conclusions, but again, I could not make final determinations without the determination of standing. Because a lot of the material is relevant to standing. And I think the material that's relevant to standing it's going to come. You certainly have the right to establish standing, but it's not yet been stipulated, conceded, or established. So things have the right to admit that kind of evidence. But I understand and will reassure that you're not waiving your objections by failing to repeat them. Here, we don't need to take the time to do that. And with respect to evidence that has been offered and objected to, if the court sustains objections to some of that evidence, you will be deemed to have made an offer of proof by your written submission.
Thanks very much.
Your Honor, there are some demonstrative exhibits to which we did not object to our review, instructing us that you, informing us that you prefer that we do not raise objections as the demonstratives of the
Yes, and you don't need to, you can make those objections at the end.
At the end.
Yeah, there's some, you don't know what the theory of relevance is. Really concerned about some things like campaign materials and communiques from individuals, either proponents of or opponents to measures and whether that sort of thing is illicit. So I would rule on that eventually. So my rule is illicit. I'm not going to consider it.
Thank you very much, Your Honor. May it please the court. I am representing Chevron along with the San Ardo School District, 4 businesses and individuals who work in San Ardo and 5 royalty owners. We very much appreciate the opportunity to be here. We've given the court a couple of sets of materials. One glossary that's in the laminated blue that has also been filed. In addition, a binder that has a set of my slides that I'm going to be using, and then the individual exhibits and pieces of the record that I'm going to be, the main ones that I'm going to be discussing this morning.
I want to note for the record that I haven't checked the citations in the glossary that's been provided, but a quick glance at them seems to indicate that they are supported by references to declarations that have been submitted. So these definitions are not coming out of thin air. They have some factual basis. I haven't reviewed or studied them yet, but when I first saw them in the glossary, the initial reaction was, who says this is what these terms do? They do appear to be supported by references to them.
Thank you, Your Honor. Yes, we went to the declaration, some of the source books, Measure Z itself to create the glossary, really to help everyone along here so we all have the same frame of reference. As you will hear during these proceedings, Your Honor, we respectfully submit that Measure Z suffers from several fundamental legal flaws and constitutional problems, The most obvious is the problem that we're here this morning to discuss, which is that Measure Z is preempted by a comprehensive interlocking web of state and federal statutes and regulations that encourage and regulate oil production activities, and in particular subsurface oil production activities. And my main theme today, you're going to hear, Your Honor, is that the briefing in this case has made the issue much simpler for the court to decide. I know it's a voluminous record, but the key thing is that the county and the interveners now concede that, based on the Attorney General's 1976 opinion, the Senate Bill 4 Environmental Impact Report, that state law does indeed preempt local regulation of subsurface oil production activities. So that really leaves the main question for us today to be, does Measure Z regulate subsurface activities? And I think the answer is clearly that it does. That's its focus, that's its aim, that's its essence, and it's therefore preempted. My game plan today is as follows, Your Honor. I thought I'd start with an overview of our arguments, and we've coordinated amongst ourselves on the plaintiff side so there's not repetition, but an overview of our arguments on preemption. Then I thought it might be useful to just walk through an overview of San Ardo Field and how it functions, and put that in context with the preemption arguments based on the evidence and the declarations in my slides, including the animations are all based on declarations in the record and material.
That's funny. And I want to interject at this point that this background evidence that's been submitted is really, in the court's estimation, essential to understanding many of the issues in this case without getting into as applied challenges to the measure itself. These practices, terms, the geologic composition of South Monterey County and the oil deposits there in South Monterey County don't exist in the background information. I think it's essential to understand and trying to interpret what this measure does.
We agree, Your Honor, because I think it's clear the court has delved deeply into these issues. The regulatory framework, both the federal Safe Drinking Water Act, the California Public Resources Code, the primacy of DOGGR, the Department of Oil, Gas, and Geothermal Resources, it all ties into what's happening underground and the really unique operations at San Ardo Field. And so I'm going to walk through that. Then I'll follow up with a more detailed discussion of the federal and state regulations and statutes. Then I briefly discuss the preemption standards and apply those to Measure Z to show why they're preempted. The next phase of my argument will be to explain why the land use cases that the county and the interveners have relied so heavily on don't get them home. They don't. It really, when I walk through the interpretations that the county and interveners have gone through, it's clear the land use line of cases, land use invocation is a pretext for regulating oil and gas activities because nothing is going to really change based on what Measure does in terms of the surface activities. And then finally, I will discuss severability and obviously be ready to answer any questions the court asks. So let me start with an introductory overview of our arguments. Everyone seems to agree that state law, the Public Resources Code, and the DOGGR's responsibilities preempt and preclude local regulations of what happens below the ground. Underground activities, we refer to them as underground, subsurface, downhole activities. Measure Z, on its face and in its effect, regulates downhole activities. That's what it's all about, and that's why it's preempted. The reason for preemption, the reason that the state has occupied the field with respect to subsurface activities in this way, with the impetus of the federal government under the Safe Drinking Water Act, is that oil-bearing formations are underground. They don't have any respect for local boundaries. The oil flows beneath the ground through the state, and therefore it's important to have a uniform system of regulatory authority and not a patchwork of laws. It's an area of paramount state authority. We also need to produce sufficient energy and in order to thrive and succeed as a state and for purposes of national security. Energy independence is an important national goal. And we also need to protect our environment and to balance the needs for energy and for oil production with important concerns regarding environmental safety and safety in general. So our state and federal governments have enacted this intertwined regulatory regime that aims to do what Section 3106 of the California Public Resources Code says, to encourage the wise development of oil and gas resources. As the court knows, the state of California has vested authority to regulate subsurface activities in the Division of Oil, Gas, and Geothermal Resources, DOGGR, which is part of the Department of Conservation. And the Public Resources Code talks about the fact that one of DOGGR's key objectives and the state's objective is to both protect natural resources from damage, to increase their extraction in a way that is supportive of maximizing our ability to extract oil and gas, and at the same time protecting the environment and other facets of our state. DOGGR employs about 200 people, and they've got geologists, petroleum engineers, hydrologists, and by way of the detailed array of statutes and regulations, they have completely occupied the field of subsurface regulations, regulating and monitoring what happens beneath the surface of the earth in connection with oil production activities. It is an expert agency. Measure Z, however, seeks to transform the county for all its great qualities. The county of Monterey is not an expert in oil production, let alone subsurface activities. It doesn't have a staff, it doesn't have scientists, it doesn't have the people who can make the decisions about what is consistent with the law and nature and the goals of our state system. State law comprehensively regulates subsurface activities, and it gives DOGGR the power to enforce these laws. The bedrock of these principles, Your Honor, of this legal framework is Section 3106. You're going to hear me talk a lot about it because it's really an extraordinary provision. I have an excerpt up on the screen. As I mentioned, it declares that the purpose is to encourage the wise development of oil and gas resources, but it also, among other things, instructs that DOGGR shall permit owners or operators of the wells to utilize all methods and practices known to the oil industry for purposes of increasing the ultimate recovery of underground hydrocarbons. And it goes even further for our purposes, Your Honor. It's really rather extraordinary. And I'll get into this in more detail when I delve into the framework. But among other things, it expressly says that unless a lessor and lessee agree otherwise, parties can agree not to perform certain operations, then the state of California's policy, and it says this in the statute, is to deem it lawful for the operator to use all reasonable means and methods to extract oil, including, and this is the clincher, injection of water and other substances to make oil less viscous so it can be extracted. That's exactly what Measure Z is seeking to regulate and prohibit, and that's why we're going to demonstrate that Measure Z is prohibited, is preempted. I mentioned the California Attorney General's opinion, which is going to be another refrain that you're going to hear from me. It was 1976 opinion, and it has attracted a rare level of unanimous praise, basically, and endorsement. It's never been questioned by the Attorney General since 1976, or by the legislature, which is presumed to know that the Attorney General has made proclamations like this. It followed on the heels of two prior Attorney General opinions, and then it gave a more specific analysis of the preemption of subsurface activities by state law. And it declared that the state has preeminence and occupies the field with respect to subsurface oil and gas production activities. And it noted that it pointed to Section 3106, it pointed to the fact that there were significant regulations and statutes, but since then, many more statutes and regulations have been enacted that have filled the field even more, including Senate Bill 4, which expressly permits some of the various subsurface activities, that, including hydraulic fracturing, which we'll talk about more, and other well stimulation techniques that Measure Z seeks to prohibit. But put aside what SB4 actually does, Your Honor, it was another opportunity for DOGGR to analyze its authority and to determine whether there's preemption. And this was in 2015 in the Environmental Impact Report that Senate Bill 4 ordered be prepared by DOGGR and the state. And in the Environmental Impact Report, DOGGR declared that the detailed requirements of state law and regulations reinforces the Attorney General's opinion in 1976 and said that such detailed requirements simply leave no room for additional actions by local governments, like the County of Monterey. And no one, the interveners of the county, is disputing the accuracy of that statement. So that's my guiding light for today, Your Honor, because I think the county, for example, has adopted the Attorney General's interpretation, the line between above ground and below ground. And if we go to the next slide, you'll see, Your Honor, that they were talking about cases and the line between exclusive authority for DOGGR and the state and the below ground and above ground activities where the local zoning may come into play, and noted with approval that the Attorney General concluded underground phases of oil and gas activities appear to be fully occupied by the statutory scheme. So we have common ground, no pun intended, I think, on that with the county. The interveners go even farther. They call the 1976 opinion of the Attorney General one of the seminal resources on this preemption question. They note that state laws occupy a discrete field of the technical specified aspects of downhole oil and gas activities. And they note, again quoting the Attorney General, that the preempted subject matter is confined to downhole for subsurface operations. So that really sets the table for us, Your Honor. The question is, does Measure Z regulate downhole activities that are preempted by state law, the Public Resources Code, SB4, and the many other state statutes and regulations that cover this? And Your Honor, we submit that on its face and in its effect, Measure Z clearly does that. As the court knows, there are 3 proposed amendments to the general plan. One would ban well stimulation, including hydraulic fracturing and acid stimulation mechanisms. That is the essence of an underground activity. It's banning stimulating the wells below ground. It's just the English language will not allow us to call that anything but a downhole activity. Injecting substances or taking actions below the ground to stimulate the well to make it easier to get oil out of the ground. That is below ground. And SB4, Senate Bill 4, not only permits and regulates well stimulation treatments, Your Honor, but the findings say that it encourages the use of water for well stimulation treatments. Measure Z seeks to ban exactly the precise downhole activities that Senate Bill 4 encourages and regulates, and therefore Measure Z is preempted. The underground injection ban, what could be more subsurface than injecting water and steam and into the ground below the surface, thousands of feet below the ground? The state and federal governments have a partnership on underground injections, a detailed federal statute, as the court knows, the Safe Drinking Water Act, which then allows the U.S. EPA to give primacy to the state if the state wishes to take it, and to regulate these actions. But as I mentioned, Section 3106 says the state, as a matter of policy, deems it required, and there's a copy, just for the court's convenience, in the side of the binder, I put a loose copy for the court, section 3106. It literally makes a state policy to deem it lawful to engage in underground injection of water, other fluids into the productive strata, also the application of pressure, heat, or other means for the reduction of viscosity of the hydrocarbons. And as the court knows from reviewing all this material, that's the key process at San Ardo Field that's required to get the oil out of the ground. It's heating the oil to make it less viscous. The new well ban, again, drilling a hole into the ground, deep into the ground, is the essence of an underground activity, a subsurface activity. And it's highly regulated by DOGGR. And as I'll discuss, everything's interconnected. The drilling of new wells is crucial to the injection program and to the heating of the oil through steam in the steam chest. And I think it's also crucial in its interaction with the underground injection program that's regulated by the EPA and by DOGGR. So Measure Z, on space and in effect, seeks to regulate the drilling of new wells, no matter how it's interpreted. The county has said that now replacement wells, they're okay under Measure Z, and they've said that sidetrack wells are okay. They're getting into the business of picking and choosing about what types of wells can be drilled underground. Subsurface activity, it's preempted. The main response from the county and the interveners is to argue that even though all these things do happen underground, this initiative is only regulating the surface areas. They're basically asking the court to say downhole means up. That even though it's below ground, they're regulating what can happen on the surface, and therefore this is just surface regulation. But that would make it meaningless, because as human beings, we can't do anything under the ground without starting the process off on top of the surface of the earth. The key is the activity that they're regulating, subsurface. And as I will elaborate on here in a moment, it clearly does. With respect to the land use umbrella and the shield, or the source of authority, particularly in light of the interpretations that the county interveners are now giving Measure Z, as the court will see, nothing will really change in terms of the subsurface activities at San Ardo Field. The same sorts of drills, the same sorts of rigs will be there. New wells that are drilled will use the same drilling material and equipment. It really is, the land use argument is a pretext for really just getting into DOGGR's world underneath the ground. So, Your Honor, with that, I would like to move into, actually, just to summarize, this will kind of lay out where I'm going to go, my refrain here. I have a bit of a syllogism here. It's that everyone agrees regulation of subsurface techniques and activities is preempted, as explained in the 1976 Attorney General opinion. County interveners agree with that. And I'll get into more detail on that from the briefs. DOGGR, as I said, in the Senate bill for environmental impact report, makes very clear that it agrees with the Attorney General opinion, and that Senate Bill 4 and other regulations since 1976 make it even clearer. DOGGR, the state, have exclusive regulatory authority over underground activities, and as I said, Measure Z regulates those activities. So it's preempted. Now, into the background of San Ardo Field. First, the setting. Where is it? What does it look like? It's located in the Salinas Valley. It is south of San Ardo, nowhere near the city. So here we are up in Salinas. We're panning back out for the record. There's Monterey and the ocean, and Carmel by the sea. San Ardo Field and the oil operations are nowhere near those areas, or not in any sort of residential or city or anything like that. Down 101,
And there we are. And Your Honor, for the record, the green area, with the green outline, that's the area of San Ardo Field that's operated by Chevron. And then the blue area is, the blue outline is where Aera operates. And that's San Ardo Field. And then the pink up there, I believe that's where Eagle does some operations. But the core is here, and Chevron is the green outline. San Ardo Field is the 8th largest field in California by current production. Oil was discovered in 1947, so oil production has been going on there for a long time. The county granted a conditional use permit to the Texas company, which became Texaco, which became Chevron. In 1949, the permit was granted. And it was broadly worded. It said that the operator may drill for and or remove oil, gas, or other hydrocarbons. And that's Exhibit 7 to our request for judicial notice. Now the geology. And I think, as the court was suggesting, these issues all become really relevant and important in determining whether there's preemption. There are several deep layers of earth called formations at San Ardo Field where the oil is found. There are about 2,000 feet or more below the surface of the earth. The deeper formation is the Orradre formation, and that's where Chevron first began oil production activities. Chevron is currently producing oil from what's called the Lombardy sand, which is above the Orradre. And that's where it's currently producing oil from. It's no longer producing from the Orradre sand. And as I said, the formations are made of sand, not rock, and they do have a degree of permeability that does makes it so that oil can be extracted. Now, in these formations, there's not just oil. There is a lot of water. In fact, way more water than there is oil. When Chevron pumps the formation, 95% of what comes out is water mixed in with the oil, which is about 5%. So there's huge quantities of water that come out with the oil. The water quality in the formation is poor. It's salty and dirty because it's mixed with oil and other sediment. And this will become even more important when I talk about water use and disposal of the produced water. The chemistry. The oil in the San Ardo field is heavy crude oil. It has a very high viscosity. The oil on the left of the screen is medium viscosity. On the right is heavy crude that approximates the crude oil that's in San Ardo field. And it's like one of our witnesses, Mr. Tubbs, one of the lead engineers at the field for many years, called it a consistency like ketchup mixed in sand, which I don't find particularly appetizing. But one of the other experts, Mr. Kemp, in their report, said it was like roof tar. And so it's not flowing freely on its own when it's in the field. The viscosity of the oil obviously makes it challenging to get it out of the ground, particularly since it's in sand and water. And so Chevron and others look for a process to make that possible, and that is the steam flooding process. So the steam flooding process, at our hearing last week, Your Honor, you mentioned cyclic steaming, which is a variant of the steam process that was used in the early days at San Ardo Field. But now Chevron uses steam flooding. In that process, in order to lighten the oil, it involves heating the produced water, a quantity of the produced water that comes out, and then injecting it back, and converting it to steam and injecting it back into the earth, back into the Lombardy formation in order to heat the oil and make it less viscous. And we have an animation that just demonstrates, based on the declarations, how it functions. You have this steam injector goes in, the steam blows out, starts to fill the top of the formation like smoke in a room, and then continues to fill.
And the steam is generated, as I mentioned, and I'll get into this in a bit more detail. The oil is separated from the water during the process once it's all out of the ground, and then the water is softened and filtered, and then it's converted into steam using steam generators.
So essentially, the process is, as oil is removed, more steam is necessary to fill the chamber.
Yeah, in fact, it's necessary, but the more oil and water that's removed is helpful and in fact crucial to being able to continue to build what's called the steam chest and to allow the steam to really keep heating. So you're exactly right. And in fact, the steam chest, it's not, the cyclic steaming is more of a targeted thing where you use the production well to heat the oil right around the well. The steam flooding seeks to do that. There's one steam injection well for about 8 of the production wells that pump the oil out. So that's important in the immediate term. But the bigger goal is to create and maintain a steam chest that builds and builds and spreads underneath the field in order to heat the oil. And it's part of what's called enhanced oil recovery. It's another term you'll be hearing from us. And so it's like the steam chest is like a garden. You have to tend it, you have to keep it building and maintaining, and it's a very highly valuable asset because it's so expensive to create over years and years and years. And the animation, this is from Mr. Tubbs' declaration, paragraph 44, shows how the steam chest, its hottest is in the orange and it's blue, it's not as hot. How it has spread and built over the years, and that allows production to expand and spread and go farther and farther out in the formation. And this, Your Honor, in terms of this goes to your question or your comment, that as water is removed, that lowers the pressure of the formation, and then allows it allows the steam chest and its integrity to remain intact, because the more pressure is there, the harder it is to there's no room for the steam to go. So it's all really closely linked together. As I mentioned, significant time and capital investment going to building and maintaining the steam chest and monitoring it. It's extremely expensive to generate the steam, keep the steam in terms of just the power that's required to do that.
Is the expense relevant at this stage of the pursuit?
On the preemption, Your Honor, it's just really a background fact, because I think these background facts are crucial, but I'm going to keep coming back to this is downhole. Downhole activity, that's preempted. And to grow the steam chest, Your Honor, it's crucial that Chevron drill new wells, and this links up to section 1.23 of Measure Z, into the borders of the steam chest. If Chevron stops drilling new wells, and this, Your Honor, the Tubbs declaration at paragraphs 58 and 59 talk about this. The steam chest will collapse without new wells being drilled.
Yeah, the more oil that is removed, greater the unoccupied area, if you will, in the chamber there is, which has to be replaced with steam, which necessitates the steam injection.
That's exactly one part of it. And in fact, it's also important to drill new wells at the edge of the formation, because there's this constant battle with cooler, with water at the edges, which will be fighting the steam and cool it. So by drilling new wells at the edge, that allows more water to be taken out, more room for the steam, and then the steam can heat the oil. And it's like the cycle of life, and then more oil can be extracted. And on these issues, this evidence from the Chevron plaintiffs and others, it's undisputed. There's nothing from the interveners, nothing from the county, and it's just basics about how the field operates. The steam chest is regulated by DOGGR, which approves every underground injection project first, and then every well that relates to the steam chest and its maintenance and its functioning. And DOGGR obviously understands the reason for these underground injection projects and why new wells are necessary. Now, the produced water, because this is really, I think, crucial to everything about Measure Z. We have, for the record, I have on the screen a slide that shows what happens to the water. And then, Your Honor, I brought some samples for the court, which my able partner, Mr. Dinser, will display for the court. The way this works, Your Honor, as I mentioned, 95% of what comes out with the pump jack is water mixed with oil, and that's bottle 1 that Mr. Dinser is holding up. And for the record, it's black and appears dirty. That's what comes out of the wells. Bottle number 2 is a bottle of oil after the water has been taken out of it in the oil-water separators. And that goes off, and actually it's now in the oil plant. And so the numbers on the bottles correspond with the numbers on the chart. And we can provide a photo, too, of these samples for everyone, so you just have, for the record, that might be good. Bottle number 3 is a sample of the water that Chevron injects back into the ground using steam injection. So on my chart, this water takes its path and it goes through filtering and softening, so it can be then put in the steam injectors and the steam generators and injected through injection wells back into the ground. And you'll see the color, Your Honor, it's a light yellowish, it's a bit cloudy, looks a lot better than bottles 1 and 2 in terms of clarity. That's converted into steam and then injected back into the ground as part of the maintenance and building of the steam ships. Bottle number 4 is a sample of the water that gets injected right back into the Ardo formation, 2,000 feet below the surface. So this is just basically pure disposal of the water, something that Measure Z bans. But it's crucial because 30% of the water goes into the steam injection. 30% of the 95% that comes out of the ground with the oil is steam injection. 45% is disposed back into the Ardo, the past oil-bearing formation. And Your Honor, in bottle 4 you'll see it's yellowish, more yellow than bottle 3, has some sediment in it. It's basically exactly how it exists in the ground before it's taken out, except it doesn't have the oil in it. And so that's re-injected into the Ardo and disposed of. Bottles 5 and 6 are very interesting bottles, I think. Bottle 5, well, both of them are products of the reverse osmosis facility that Chevron went online with in 2007, and that DOGGR has given commendations and awards to. Bottle 5, 25% of the water goes through the reverse osmosis facility. Bottle 5 is very yellow. And bottle number 6 is filled with clean, purified water. Bottle 5 is the brine stream, super salty water that's produced as a result of the reverse osmosis. And then bottle 6 is the purified potable water that is the product of the reverse osmosis facility. The brine is re-injected into the Ardo through injection wells. But it's, I think, really interesting in terms of what happens with the other water, the purified water. After the purification process occurs, the water is sent through constructed wetlands and into a groundwater recharge basin. And it's about 520 million gallons of purified water per year to the county for beneficial use. And on the left is the wetlands, and then you have the recharge basin on the right. And so this goes back in and goes back into the groundwater formations. This process is regulated by DOGGR, but also by the state and regional water boards as well.
And this point is contention actually that you cannot purify any of this water without storing it.
Yes, Your Honor, that's correct. The storing, there's here it's impounded, it's being stored, it goes, it's part of the process of, it's the reverse osmosis process. First you have to store it, you have to run it through the reverse osmosis membranes, and then as it percolates here, it's impounded, and this is large quantity of water. There'd be no, to make this clear for the record, there would be no economical way and no feasible way to operate at San Ardo Field unless there are ways to purify and recharge the groundwater or dispose of the oil, the water into the ground. Because there's no pipeline, you have to use trucks to take the water away. So this is an example of how this is really an ecosystem where everything is connected. The production wells produce water and oil. Some of the water is then used to produce more oil and water via the steam injection that creates the steam chest and builds it. Some of the water is injected back into the oil-bearing formations from which it came, and then the rest of the water is purified through reverse osmosis and returned to the county for beneficial use. So they go on, the water goes on different paths, but each serves a different purpose, and it makes it a self-contained ecosystem that's highly regulated by DOGGR, by the water boards, by the EPA, if it ever needs to get take regulatory authority. So that's the water. And I've mentioned it several times, just briefly, let me walk through the types of wells so the court can envision what we're talking about. And this is, again, this slide is based on the Tubbs Declaration. First thing you'll love, Your Honor, is that in terms of drilling new wells, it all looks the same. The same type of drilling rig is put there, and then a hole is drilled. What's may differ is the uses to which they're put and what happens under the ground. So vertical production well, that's what the typical well we think of that pumps the oil from the ground. The sidetrack well, which you've probably read a lot about, is a well that can be drilled when something is not functioning right with the vertical production well. Either it's not getting to the oil, it's blocked from it, or it's just not functioning right. The operator can drill back down through the production well and then sidetrack out the side and then drill a new bottom hole, a new place to get the oil out of the ground.
One of the issues and contentions in this case, a sidetrack well would be a new well.
Correct, Your Honor. And I believe the county and the interveners are taking the position that it would not qualify as a new well. But whatever it is, and I think the fact that they're making that determination shows that really the county is getting into the business as an oil and gas regulator, which is territory occupied by the division. Another type of well, Your Honor, is the horizontal well. It's basically like the production well, and it drills down, you drill down, and then instead of just having the bottom hole being right below the cylinder of the well, the company drills to the side horizontally, which allows it to cover more of the formation and therefore pump out more oil. The disposal well is the well that is used to re-inject the water, either the brine from the reverse osmosis facility or just the water that is immediately disposed with, sent back to the Ardo formation after it's produced. Temperature observation well is just what it sounds, and again, these are things that DOGGR monitors closely to the observation well monitor the temperature and various depths of the formation, very important for safety concerns as well. And then finally, the steam injection well, exactly what it sounds like. You drill down, that's what's used to inject the steam back in to heat the formation so that oil can be extracted. And again, each of these types of wells must be approved and permits must be granted by DOGGR before they can be drilled and be up and running. And then just finally on San Ardo Field, briefly, how do they look from the surface? We're all familiar with the pump jack, and it's the same for the vertical production well, a sidetrack well, and horizontal well. And then the disposal, temperature, and steam injection wells have a different head on them. But there's really only two different looks that you'll see on the wells in terms of what you see from the surface. So that, Your Honor, is my tour of San Ardo Field, and I'm happy as we go to answer other questions. But it will, I think, it links up with the preemption analysis I'm about to launch into. And I think the place to start is, what are the regulations in California and federally that cover the same topics that Measure D cover? The place to start, I think, is the Public Resources Code, which makes very clear that oil and gas production is a matter of paramount statewide concern. Section 3400 declares that the people of the state have a primary and supreme interest in the deposits of oil and gas within the state. And it goes on to say that it's supervised and protected by the state via DOGGR. So it's the people of the state, not of the county. We're all in this together. It's a natural resource of the state. And as I mentioned, we need some degree, we need uniformity of regulation. Section 3106, as I said earlier on, I think answers a lot of questions in this case. Section 3106, subdivision D, declares to best meet oil and gas needs in this state, the supervisor, which is how they refer to DOGGR, shall administer this division so as to encourage the wise development of oil and gas resources. So I know it can become an issue of controversy about, in the political realm in particular, different people have different views about how much oil exploration and extraction should occur. But the state policy is we need to develop oil and gas resources, we need to do it wisely. So that's the state policy. And it goes even further. As I mentioned earlier, the Section 3106B is the provision that says that DOGGR shall permit the owners to use all methods and practices known to the oil industry for the purpose of increasing the ultimate recovery of underground hydrocarbons. It doesn't say it should consider doing that. It doesn't say, make determinations. It's all methods and practices. And the next passage in 3106B clarifies that a little bit, but it's even stronger. It goes on to say, and this passage is in particular important because it makes it a state policy to increase the recovery of underground hydrocarbons, but it says that to further the elimination of waste by increasing the recovery of hydrocarbons, it's hereby declared as a policy of this state to allow an operator to do what a prudent operator using reasonable diligence would do, having in mind the best interest of the lessor, lessee, and the state in producing and removing hydrocarbons. So unless the lessor and lessee, if we're talking about a leasehold, restrict things, it's the policy of the state that the operator should be able to do what a prudent, reasonable operator would do to remove hydrocarbons like oil. And so I'll come back to this, but this makes this so different than any of the other preemption cases, like City of Riverside, Big Creek Lumber, or here we have not just a law that regulates, we have a policy that encourages hydrocarbon development in a way that is basically reasonable and state-of-the-art. That's state policy. Section 3106 goes on, I mentioned this just a few minutes ago, that the prudent means that can be used and that are deemed lawful by Section 3106 directly bear on this case and on Measure D. These activities that are deemed lawful by the state as state policy include the injection of air, gas, water, or other fluids into the productive strata, the application of pressure heat or other means for the reduction of viscosity of the hydrocarbons, when these methods or processes employed have been approved by the supervisor. Again, that's DOGGR. So that process that I just mentioned, the steam flooding process, the injection process, the drilling of new wells to allow that to occur, California, and this, I believe this provision was added in 1970 in section 3106, but California, as a matter of state law, has enshrined in a statute as the policy of the state that the exact things that Chevron and others do in San Ardo Field, those must be allowed to continue. It's right there, it's in the statute, it's the policy of the state, and Measure D cannot interfere with that. That brings me to the Attorney General opinion, which I mentioned earlier. The Attorney General was operating in 1976, and as I said, I've read a lot of state and federal Attorney General opinions. Rarely have I seen one that attracted less controversy or challenge. It stood the test of time, so to speak.
Rarely have I seen one cited from both sides.
That's true. It's that good, Your Honor. It's that good. I respectfully submit we get the better of this argument as the Attorney General's opinion, because it declares that the statutory and administrative provisions appear to occupy the underground phases of oil and gas activity. And the Attorney General, when analyzing the landscape, it looked at all the land use cases up until 1976, and all but one of the cases that the county and the interveners cite predate 1976. And the Attorney General said, well, those cases just don't tell us anything because they don't talk about preemption. They're not looking at conflicts between local bans on oil drilling in particular residences or areas and measuring that against state law. And state law has gotten even more rigorous on its regulations. And again, it goes even further. The Attorney General makes the point that I made at the outset, that conservation and protection of the state's finite energy resources by means of this regulatory policy, it transcends local boundaries and interests. And the Attorney General said these are far-flung around the state. We're all citizens of the same state. You can't leave this to a checkerboard of local regulations. And that was one of the bases for the preemption finding. Now, it's important to note there's some, all sides here are citing the Attorney General's opinion, but I think any equivocalness, if that's a word, I think is really resolved by what DOGGR said in the Senate bill for environmental impact report. Because in that, as the court knows from the briefing and everything else, when part of SB4, the law passed in 2013 by the legislature and signed by the governor, was that required an environmental impact report to evaluate the impacts from well stimulation, including fracking, and to come up with mitigation measures. And it was subject to comment and from everybody who wanted to comment on it. And the DOGGR unequivocally embraced and endorsed what the Attorney General had said in 1976, said that the detailed technical specifications in SB4, let's go back to the prior slide, reinforced the conclusions by the Attorney General. So DOGGR saying that even before SB4, put aside SB4 and well stimulation, the requirements of the law simply leave no room for additional actions by local governments. And then SB4 made it even clearer by authorizing, encouraging well stimulation treatments and giving DOGGR the authority to regulate it. The DOGGR went another step, said based on the Attorney General's opinion, based on SB4, it opined, and it's the expert agency that gets deference in these circumstances, it has exclusive legal jurisdiction over and thus occupies the field regarding subsurface regulation. That's pretty clear. And we'll see what the county and the interveners have to say, but I read their briefs very carefully. They don't dispute what this says, and in fact, the interveners brief picks up on exactly the language and just says it's limited to subsurface activities. And so this means, quote, according to DOGGR, quote, that no other state or local agencies can impose regulations or mitigation on top of those by DOGGR in that context. As we will discuss, that's, however, exactly what Measure Z does. To carry out the intent of the legislature, DOGGR has promulgated an array of detailed regulations that touch on virtually every aspect of oil production, in particular subsurface activities. And Your Honor, we submitted a declaration from Mr. Ellison that talks about some of those and lays out relevant, particularly relevant regulations that bear on these issues. Briefly, the federal policy overlay. Increasing our safe and environmentally sensitive oil production in the United States is a bipartisan issue, and it's a federal issue as well. President Obama in 2012 said that a key part of our energy strategy is to increase safe, responsible oil production here at home. That's cut across administrations of different political parties, and it's exactly the policy of California as articulated in Section 3106. To increase our energy production, to do it in a way that's respectful of the environment, that's respectful of safety concerns, that's innovative, and that's what Measure Z is running up against. It's going a different direction, and that is conflicting with this federal policy. Moreover, the Safe Drinking Water Act that the court mentioned at the outset, Congress tried to strike a balance, and it recognized that there needs to be a safe way to inject and dispose of substances and injecting things into the ground. But it wanted to protect underground water resources while not imposing unnecessary requirements which would impede or interfere with oil or gas production. And this is from the legislative history that I'm quoting. And so it's a balance. The Congress said we want to protect the water, but also want to protect our ability to extract oil and gas in a safe and environmentally sound way. And that's baked into the statute itself, which also restricts the EPA and therefore the states from unnecessarily impeding oil production. As the court noted, the EPA has delegated primacy to DOGGR to comply with the Safe Drinking Act. And as part of that, DOGGR has established an underground injection program. It's got detailed regulations. It's a state and federal partnership that EPA is still part of that seeks to strike a balance here. But Measure Z, as we will discuss, seeks to ban underground injection of water and for storage or disposal. As a result of these federal and state regulations, Your Honor, as the DOGGR said in the SB4 EIR, California has the most rigorous regulations in the country for oil and gas exploration, development, and production. So we have the most rigorous regulatory regime in the country as a matter of state law in place, and we respectfully submit, and I hope I can convince you, it occupies this field of subsurface regulation. DOGGR, just quick examples, Your Honor, I know in terms of the kinds of things it does, it has to approve all underground injection projects. And so before you come up with something like Chevron did in terms of the intricate relationship between injection loads, the production loads, the steam jets, you have to get approval for the overall project. It then, any wells that are drilled in order to engage in underground injection of water or other substances requires permits for each well to drill it, to rework it, or to abandon it. DOGGR creates field rules for particular fields. So there's a set of rules for the Santa Rosa field that are tailored to the field itself. And then, of course, there's the web of operating statutes and regulations, as I mentioned, are discussed in Mr. Ellison's declaration, as are these other features. And then, if I go to the next slide, we have it from the county's own expert, Mr. Erzlach, who was asked during his deposition, would it be fair to say that DOGGR is responsible for regulating oil and gas operations? Yes, he answers. They're responsible for oil and gas wells, the drilling, workover, abandonment of those wells. Question, all aspects of oil production? Yes. So the county's expert agrees that DOGGR is responsible for all aspects of oil production in California. That's the federal and state regulatory background that we respectfully submit occupies the field, and we submit Measure Z contradicts, duplicates, frustrates, and therefore is preemptive. So with that, I'll turn to the preemption principle.
Well, this is probably appropriate for recess for a few minutes, and then we'll go for a break and stand. So we'll resume.
Thank you, Your Honor.
Remain seated, come to order. Court is again in session.
Okay, we're back on the record in Measure Z cases. Mr. Butchers, you can resume.
Thank you very much, Your Honor. I will now turn to the governing legal principles that guide us in our analysis of preemption today. The first principle I wanted to focus on relates to the initiatives, and I think again there's language that say an initiative must be construed liberally, but the cases make very clear that the same principles that apply with respect to a statute apply to an initiative. Namely, first you look at the plain language of the statute. If the plain language answers the question, you don't consult ballot materials or other materials. And particularly pertinent for our purposes today, if an initiative it must give way when the issue is one of paramount state concern. So a ballot initiative is just as subject to preemption as a statute or any other local law. The California law, Constitution subordinates local laws to state law, or what the Constitution and the California Supreme Court refer to as the general laws. The Federal Supremacy Clause empowers Congress to preempt state and local laws. And there are a number of different labels for preemption. But the bottom line is, Your Honor, I think, that we look to see whether the local law contradicts and defeats legislative intent behind a superior state or federal law. So no matter what label we put on it, whether it's field preemption, whether it's obstacle preemption, conflict preemption, if the state, for example, indicates a policy, encourages activity, permits activity, and a local authority tries to ban that activity, there's a conflict and the local law must give way. The California Supreme Court in the city of Riverside put it this way. That preemption exists if there's a conflict in state law, and a conflict exists, if the local legislation duplicates, contradicts, or enters an area fully occupied by the general law. So just to run through some of the formulations with respect to preemption. First, of course, in state law, there's field preemption, and there are two types. One is where the comprehensive nature of the statute is so thorough and detailed as to manifest the legislature's intent to preclude local regulation. The close cousin of that is where the subject matter has been partially covered. I don't think I have a slide for this one for some reason. By the general law, and is couched in terms to indicate a paramount state concern. And I keep coming back to my friend, section 3106. That certainly indicates a paramount state law concern with respect to all the operations, subsurface activities that we believe Measure Z regulates. Another form of preemption is conflict preemption. And the Great Western Shows case from the California Supreme Court, the federal preemption, I'm sorry, jumped ahead, uses the language that
DOGGR uses an SB4, and that the Attorney General used in the opinion, the Attorney General opinion, the occupation of an entire field of regulation. Conflict preemption is something we also think we have here. And that applies where the state statutory scheme it permits more stringent local regulation of an activity. Where the statutory scheme seeks to promote a certain activity, local regulation cannot be used to completely ban the activity or otherwise frustrate the statute's purpose. And I think both the county and the interveners, their vision of conflict preemption is sort of direct. There's one species of direct preemption where if the state law says you can do these things and the county says you can't do them, they claim that's not a conflict because you could do both at the same time by just not engaging in the activity. That's not the correct version of the full spectrum of conflict preemption. The city of Riverside went on to say local governments, even if granted regulatory authority, may not wholly exclude activities that are sanctioned or encouraged by state law. And that's exactly what we believe Measure Z does. And on the point in City of Riverside, Justice Liu wrote a concurrence addressing the exact point that I was just making, that when we talk about conflict preemption, as Justice Liu put it, local law that prohibits an activity that state or federal law intends to promote is preempted, even though it is possible for a private party to comply with both state and local law by refraining from that activity. Otherwise, that would mean that state law would always be trumped by local law if local law was more stringent. And that's the argument that the interveners in the county are making. It's that, well, hey, you can comply with state law, just don't engage in activity, and then you'll comply with both. That's not the test. So now let me turn to why Measure Z is preempted. The Souter, let me go back to the Souter case. Another court appeal case, but again, said just squarely, local authorities are preempted from imposing more stringent standards and making impermissible that which the higher authority expressly permits. So maybe local authority in some instances where there's not occupation of the field can issue more stringent regulations, but they can't transcend and defeat an affirmative policy of the state or federal government to allow some sort of activity. And that's an important principle with respect to Measure Z. So let me turn to Measure Z and why it's preempted. First, state and federal law occupy the field regarding subsurface activities together. The Section 3106, the Attorney General opinion, SB4, as DOGGR put it, the Safe Drinking Water Act, together make this an issue of paramount state concern, particularly since the EPA has granted this primacy to the state of California to regulate underground injection. And I'll go back. I'll sound a bit like a broken record, but Measure Z regulates subsurface activities, well stimulation under the ground, drilling new wells, and particular types of wells, engaging. If you can do a sidetrack well, Your Honor, but you can't do a well, some other type of well, that's regulating what goes on beneath the ground. And so it's heavily regulated. And I think the preemption in this area makes a lot of sense because, as I said, DOGGR has geologists, chemists, hydrologists. They're empowered to make these determinations on behalf of the people of California. The county lacks the expertise, the resources, the personnel to properly regulate subsurface operations. They don't have the people who can go out and regulate and make approvals, and it would conflict with exactly what DOGGR does. So let me turn to the three proposed amendments to the general plan and explain why they are preempted when we apply these legal principles. First, Section 1.21, which we've already had a brief discussion about. It, as the court is well aware, bans well stimulation treatments, including hydraulic fracturing, often called fracking, and other types of well stimulation. And it says, defines that as well stimulation treatments means any treatment of a well designed to enhance oil and gas production or recovery by increasing the permeability of the formation. So this is where I think, one example, how can this not be preempted? It's underground activities. DOGGR itself announced in the SB4 environmental impact report that it occupies the field in regulating these activities. Section 3106 specifically says that injection of water and other substances in order to make the oil removable is a policy of the state. So I think under any test, SB4 is, provision 1.21 is preempted. It regulates what happens below the ground. It flatly contradicts what the legislature did in SB4. In fact, there was, as the record reflects here, there was a big debate in connection with SB4 with respect to whether fracking should be banned in the state. There was a big fight about that. And the legislature considered all the arguments on all sides. The governor did too. And as the EIR points out, the legislature authorized the increased regulation of an activity that's been occurring lawfully for decades rather than outlining the practice together. In the EIR, DOGGR notes that under Section 3106, hydraulic fracturing was permitted, and in fact it's deemed a policy of the state to allow it, unless the lessor and lessee agree otherwise. So there was a debate for the people of California whether we should allow well stimulation treatments to occur, and the legislature rejected the arguments that many organizations and individuals made that there should be an outright ban on the practice. And that's the law, that's the policy of California. It also decided that there should be careful study of the environmental impacts. So it ordered the environmental impact report where everyone could comment and come in and state their views about how this should be regulated. And then DOGGR issued regulations that regulate the process. And that's this process is what led the DOGGR to say in the environmental impact report that these specific requirements of SB4 are so detailed they simply leave no room for local governments to add further downhole requirements. That's exactly what Measure Z does. It regulates, it adds requirements, and the requirements are you will be violating this law if you engage in precisely what the SB4 allows. And back to the interveners. They quote that provision I just quoted in their brief, at page 35 of their brief, and they don't say that's wrong. They don't say we disagree with that. They say that it underscores DOGGR's oversight under SB4, just as it has historically been, is focused on downhole requirements. And interveners do not dispute that a local government cannot layer conflicting downhole requirements on top of these state requirements. So how can SB4 not be preempted when careful consideration by the legislature, by the government, by the expert agency, notice and comment on the environmental impact report, and the county comes along, the voter initiative comes along, and votes to ban exactly what the legislature decided to permit and to create requirements and restrictions. And it's just absolutely clear preemption. And the language of the findings, Your Honor, finding E, I mentioned this before, but seeing it in black and white and red, the legislature encourages, so it's not that they're standing by as a neutral arbiter. We're just going to let this unfold and see what happens. The legislature encourages the use or reuse of treated or untreated and produced water for well stimulation treatments and well stimulation treatment related activities. Couldn't be clearer. And one of the things that strikes me about SB4 is that it notes and sort of makes it sound like a positive. This is in effect, section B, under section 1, or section 1D, the effect of the initiative. It notes that it tracks state law in defining the terms, including well stimulation treatments, hydraulic fracturing, etc. But that doesn't help the initiative survive because it tracks state law up to defining the terms and then it banned what the statute, what SB4 encourages, well stimulation under tight regulation by DOGGR. So that is field preemption, it's conflict preemption. It really couldn't be clearer. The county intermeters have pointed towards what's Public Resources Code section 3160. You can talk about it as a savings clause, but all it says is that this article does not relieve the division or any other agency from complying with provisions of existing laws, regulations, and orders. That can't possibly mean that all the preemptive authority that DOGGR clearly has goes out the window. And it at most means that DOGGR must comply with existing rules at the time, like CEQA and other laws that have some relationship to what's happening in terms of well stimulation. But the downhole activities, that is regulated by DOGGR and exclusively by DOGGR under this provision. And I did want to, while we're on section 1.21, Your Honor, if it's okay with you, I just wanted to talk about this, the language and there is no definition of maintenance treatments, and I think the court was suggesting that perhaps there was a way to read in the definition that DOGGR has established in order to somehow save the initiative. But I don't think that will work, and it certainly doesn't solve the preemption problem, because Chevron currently uses acid cleanouts, which are covered by section 1.21. Measure Z contains in its text no way to differentiate between cleanouts and stimulation. Only DOGGR has made that determination, and in fact, Mr. Burzlaff, the county's expert, when asked about this, said, no, there's nothing like that in Measure Z, that's DOGGR. So one, we have standing to challenge that, I respectfully submit, but it would be ironic in the extreme if the way to try to save the initiative was to say, we're going to borrow DOGGR's definition and then say that the county now has the same regulatory authority to make the determinations whether this acid stimulation or acid treatment maintenance has been converted into well stimulation and therefore violates Measure Z. So it's duplicative, and it would require the court to read into the plain language of this provision, language that just doesn't appear anywhere in any of the materials or anywhere else. And while I'm on it, I alluded to this, but Measure Z, the voters were convinced to vote for Measure Z. This is finding 3, C3 under section purpose affecting findings, because fracking could become widespread in Monterey County. And it goes on to say that new advances in fracking and well stimulation technologies can also enable oil and gas extraction in fields and formations that were previously uneconomical to produce. The Monterey Shale Formation underlies substantial portions of the county. Future innovations in well stimulation treatments to extract oil and gas from the Monterey Shale could lead to an increase in the number of active oil and gas wells in the county. So Chevron is an oil operations company. It does engage in well stimulation in other places. The measure was voted for by people on the theory that this could broaden, that more of it could occur. And Chevron is here, standing in court, regarding a measure that has a direct, immediate impact on it, both with respect to the specific provisions, but also what it might want to do in the future. And that's really a classic sort of challenge to, on a preemption basis. It's immediate enough as to section 1.21 to allow us to challenge it. And we have the direct problem with this acid maintenance vagueness. So that's section 1.21. Clearly preempted, flies in the face of SB4. it's clearly, and I think it's pretty clear on the face of it, it was meant to enact a different policy than the legislature did. That's what prompted it. Now, water. Section 1.22 prohibits oil and gas wastewater injection and oil and gas wastewater impoundment. So that is directly, I mean, again, this is underground activity. Your Honor, if you look at the definition of oil and gas wastewater injection, means the injection of oil and gas wastewater into a well for underground storage or disposal. So by definition, section 1.22 is regulating downhole underground activities, and it's preempted based on the Attorney General's opinion, SB4, EIR, and everyone's conception of where at least one line is drawn, and that's at the surface of the earth. The section 3106, I promised I would keep coming back to it, specifically makes it the policy of the state to allow the injection of water into the ground to heat oil as part of the process for reducing the viscosity of oil. That's the state policy. Measure Z says, no, you can't do that. Even with the broader interpretations, I know the county is taking the position that produced water that's been treated could then turn into steam. That may fall in a different category. I don't think the plain language of the word of the initiative allows for that interpretation. But even with that, they're still saying that produced water that's just injected for disposal is banned. And they're saying that the brine stream, that bottle number 5, that is crucial to being able to run the reverse osmosis, that cannot be injected into the ground under Measure Z. As part of this integrally connected ecosystem where every piece fits together in order to inject water and other fluids to heat the oil in order to extract it. That brings me to the Safe Drinking Water Act. Because I think even before we get to the Safe Drinking Water Act, Section 1.22 is preempted for the reasons I just said. But then we have this state-federal partnership. We have the US EPA in control of this program to regulate injection, underground injection of brine or other fluids. Exactly what we're talking about here. And Congress took the significant step, and now I'm quoting from Section 42 USC, Section 300H(b)(2), the actual statute, of building into the regulatory authorization for the EPA that they may not prescribe requirements which interfere with or impede the underground injection of brine or other fluids which are brought to the surface in connection with oil production. And then it says, unless such requirements are essential to assure that underground sources of drinking water will not be endangered by such injection. So that's the standard, and it's in the federal statute that then allows EPA to grant primacy to a state if it so accepts that responsibility. And as the court knows, that's what happened here in 1982. EPA granted primacy to DOGGR to regulate, to create an underground injection control program and to regulate all manner and means of activities relating to that. So permitting, inspection, enforcement, mechanical integrity testing, plugging and abandonment, oversight, drilling of injection wells, data management, public outreach, everything that relates to the underground injection of steam and water and other fluids. And that's with the full weight of the authorization of the federal government. And it includes what are called Class 2 injection wells, Your Honor. That's the enhanced oil recovery wells through injection of steam, water, gas, and the disposal wells that I just mentioned are indispensable to being able to operate at San Ardo Field. And the grant of primacy was very important. It gave what I think of as a double dose of preemption here. But as Governor Brown in 1982, I believe, in connection with the 1981, applying for primacy. Governor Brown gets to be at the beginning of this thing and still in it. Wrote a letter saying that DOGGR has effectively supervised and regulated underground injection activities related to oil and natural gas production for the past 37 years, and then it was going to keep doing that. So this is woven into the fabric of our regulatory system. And DOGGR regulates underground injection in connection with oil and gas production. And it's underground by definition. That's what it's all about. It's subsurface activities. So I think it's just clearly preempted. And to put a fine point on it, some of the preemption cases talk about if the state permits something. And most of the cases you're just talking about, the state law allows something to occur. Here we have literally permits that say you can do this. DOGGR issued a permit, and I'll come back to it, explicitly permitting its entire underground injection program. So it's got the authorization, specific authorization for drilling. And so state law allows it, but it's also got the regulated green light to engage in this underground activity. And DOGGR knows what it has to consider, that the program is going to go on, that new wells will need to be drilled to engage in this process of heating the oil. So Measure Z flatly prohibits exactly what state law allows. In each, as I mentioned, each operational well at San Ardo that conducts underground injection was approved specifically and given a permit by DOGGR. And I think it's important to remember the title of Measure Z includes protect our water. So it's aimed at exactly the objective, and it's an admirable objective to protect our water. No one's arguing that. But the same objective as the Safe Drinking Water Act, which strikes a balance that it requires the local regulators to take actions that don't unnecessarily impede on exactly the kind of operations that we have going at San Ardo Field with injection of steam and water as an integral part of the operation. There is a savings clause, or something called a savings clause, in the Safe Drinking Water Act, but one, that only applies to the federal government. It doesn't talk about whether the state has occupied the field and has preempted local regulation, but it doesn't save anything here, because it says that nothing in this chapter shall diminish any authority of a state or political subdivision to adopt or enforce laws or regulations respecting underground injection. But no such law or regulation shall relieve any person of any requirement otherwise applicable under this subchapter. So we have a couple answers to that. First, we've cited cases from the other context, the Blue Circle Cement case, for example, that say where a law saves and allows local or state regulation on a topic, and the local entity comes on and bans the activity, whereas the federal statute allows it, encourages it, that is preemptive. And that's what we have here. So this clause wouldn't save that sort of preemption. It also says that it shall not relieve any person of any requirement otherwise applicable under this chapter, which I would submit would include the requirement that no bans on injection be imposed if they would unnecessarily impede with oil and gas production. And here, finally, and this is probably the most important point, here, primacy was granted to the state occupied the field, and that's preemption that the state has imposed through its regulation going back long before even 1981 to regulate this through DOGGR. So section 1.22 regulates under the ground, downhole activities, it's preempted. Finally, with respect to the specifics of section Measure Z, section 1.23. This is the ban on drilling new oil and gas wells. I want to start by making the point that applies to all three of these provisions. if you look at the first sentence, it's couched with land uses and support, and I think that was very carefully thought through to try to get within the world of land use. But then you look at the prohibited land uses. It says the drilling of new oil and gas wells is prohibited on all lands within the city's unincorporated area. And then oil and gas wells means wells drilled for the purpose of exploring or recovering or aiding in the recovery of oil and gas. So drilling of a new oil and gas well, but everything in life, you're going to need to be on the surface to do something. But the entire purpose of the activity is to drill a hole in the ground, which by definition is an underground activity. So it falls within the subsurface preemption that I just have been discussing all day. We talked a little bit about the steam chest and why drilling new wells is central to that process. And I think Mr. Tubbs in his declaration, Mr. Latham also covers this, really said it best. So hopefully I described this correctly before, but just to paraphrase Mr. Tubbs, the steam chest is necessary to maintain it, to grow it, but it's fighting against the constant encroachment of water from the edges of the steam chest. And that can quickly quench it and cause the collapse of the steam chest. That's why Chevron must drill new wells, add horizontal wells, replace wells at the perimeter of the steam chest in order to avoid cooling and collapse of the steam chest through encroachment of native water within the formation. So the water is the enemy of the steam chest in a sense. The production process takes water out, which helps the steam chest because it makes it more room for it to grow and it stops this quenching problem. But it's absolutely vital. It's not enough just to replace wells that are abandoned. Sidetracking is not enough. There have to be new wells in different places. Sidetracking, you're stuck with where the well is. So it's, if you remember the diagram of the steam chest, out in those outer boundaries, it's crucial to be able to make engineering decisions and scientific decisions about when and where to drill those oil wells, or the new wells, and including the injection wells and production wells. And I mentioned this, that DOGGR in 1995 approved the steam flood project at San Ardo Field. And it's in the binder, Your Honor, that we provide. It's Exhibit 13 to our request for judicial notice. But I think what's particularly important is that it contemplates, this is just the beginning. New wells are going to be drilled as an injection well, or reworking, etc. And so part and parcel of the entire operation is the ability to drill new oil wells, new wells, including injection wells, in order to be able to inject water, to create a steam chest, to heat the oil, to pull more produced water and oil out of the ground, and then it all begins again. So we have to look at the new well ban as an integral part of the entire operation, which includes the underground injection program. And that's, you'll see it's approved. And once this was put into place, then Chevron has had to go back to DOGGR to get approval for every single well. So we have an approval, an example of an approval permit from DOGGR that I think we can put up on the screen. Let's go one more slide forward. Yeah, there it is. Your proposal to drill a well is approved, provided no program changes are made without division approval. And you'll see, Your Honor, there's, I think it's 11 different conditions and requirements that DOGGR has imposed. So it's all over this. It's what DOGGR does. It involves drilling underground into the earth. It's a subsurface activity that is preempted. And now if we go back to the prior slide, this is again from the Attorney General's opinion, and it applies exactly to these circumstances. So when the statutory scheme or supervisor specifies a particular method, material, or procedure by a general rule or regulation, or gives approval to a plan of action with respect to a particular well or field, that's exactly what you just saw in that 1995 approval, or approves a transaction at a specified well or field, that's the permit that I just showed, it's difficult to see how there can be any room for local regulation. That's exactly what we have here. We have a comprehensive program regarding the approval of the underground injection program of the specific wells. It contemplates new wells that will be available to ensure steam chest and more injection and the removal of oil. On this provision, our friends on the other side have cited section 3690, which simply does not apply here. It begins with this chapter, shall not be deemed a preemption by the state, and it relates to unitization of operations. It just doesn't have any effect here, and we haven't relied on any of those provisions.
Over on that, there's a Public Resources Code, section 3400, that you mentioned at the outset, deal with geothermal resources rather than oil and gas.
I think, Your Honor, it broadly covers, let me just pull it back down here, but I think it's certainly, the California Supreme Court is viewed as establishing this broad policy that the resources underneath the ground, like oil, gas, so I've always read it to cover everything, but let's take a look. Oh, and Your Honor, and it comes from the fining authority for DOGGR and the statutory fines that can be levied. So it's purposes of charges levied. And so, just to read the full thing, the full provision, the charges directed to be levied by this article are necessary in the exercise of the police power of the state, and to provide a means by which to supervise and protect deposits of oil and gas within the state, in which deposits the people of the state have a primary and supreme interest. So for all those reasons, we believe that basic preemption principles, the views of the expert agency, the division, the Attorney General framework that everyone has adopted means that measures be preempted because it's regulating subsurface activities. It's really layering over requirements, restrictions. I guess we appreciate to a certain extent that the county has been kind of reinterpreting Measure Z to make it less draconian. But the problem is that makes them even more of a regulator. They're going to have to be making all these determinations, they already are, about what specific types of underground techniques and operations are permissible. And that's just not an area that they're permitted to regulate in. The county relies on land use regulation, power, police power. But this is not, Measure Z is not supported, and even if it was supported by a land use purpose, I'm not suggesting they were completely lying when they said that, but even if it were, if it's preempted, whether it's for land use purposes or not. But the land use, the notion that this is just surface land use regulation, it just doesn't hold water. If we look, Your Honor, the county has said you can put in replacement wells. So I take that to mean that if a well is abandoned or shut in or it's no longer operational, you can put in a new well as long as it doesn't add to the total number of wells that exist at the time Measure Z goes into effect. So that would mean you could put in, vertical production wells, put any type of one of these wells in. The drilling process is exactly the same, as I said at the outset. So that means the land use with respect to drilling of wells, that activity is still going to occur. They also agreed that the sidetracking with no limitations could occur, but the sidetrack, the same sort of big white rig that goes over the top, that's used, even when it's just sidetracking the well. And as I read the county, they're not saying there's any limit on sidetracking wells, so that can happen. And with respect to the before and after, I was going to make a before and after. Both of them are the same. It's going to look, the land uses are going to be the same under Measure D. At San Ardo, it's going to look exactly the same. The same things are going to be happening there under the county and the interveners, at least the county's interpretation. That brings me to the land use cases that really form the linchpin of the argument on the other side. And the trio reply brief, we tried in briefing this case, we did our best to divide up issues too, so we weren't all talking about the same things. But the trio reply brief really zeroed in and walks through each of the cases and explains why they have no bearing here. But it's really it's a theme that carries through each case. Those cases were not preemption cases. They were all about whether a county or a city had the police power to restrict or bar oil operations in particular designated areas. And the Ninth Circuit in the Marblehead case, which has been cited many times, from 1931, talked about how there was a wave of these cases in Los Angeles when the population was exposing. We're talking about an urban area, it's just expanding. And so there were these real concerns about where operations were going to be permitted. And that was the only question. It wasn't whether state law preempted, it was just could you have oil operations in particular areas, were they going to be required to be stopped. So Marblehead, it does not discuss preemption. The ordinance prohibited oil and gas operations in residential areas. Not a shocker. And it held that the city may prohibit operations in certain areas, but those restrictions must be reasonable. So there are other constraints when there's true zoning going on. If we go back to the Beverly oil case, it's another case that's gotten a lot of attention. Again, Los Angeles, right in the middle of the city, residential, commercial area, doesn't discuss preemption. The court found that localities may prohibit the production of oil in designated areas, and they issued, I think, they created 3 different zones, and one operator was in the zone where it was going to be banned, when reasonable and not arbitrary. But the court did cite Section 3400 in that, but there was no preemption argument. The court said that localities do have the ability to make sensible decisions that are reasonable and not arbitrary about designated areas. But that's not what Measure Z does, number one. It doesn't purports not to prohibit oil operations. Instead, it regulates the techniques under the ground that can be used in the method and mode of operations. So it's just completely different than Beverly Oil. Same thing with the Pacific Palisades case, which is, I think, my third. Right, the next one, actually Hermosa Beach. There's Pacific Palisades. I'm jumping around here. Sorry, Hermosa Beach. That's the most recent case. Really, it's the only one that post-dates, I think, 1964 of the land use cases. But 2001, again, didn't discuss preemption. There was no oil operations in the city when the ban was enacted. And the court found on the specific facts there that it was a proper exercise of police power. No discussion of preemption. But these cases do not have a bearing on this. And that's what the Attorney General said in that 1976 opinion. So Pacific Palisades, same thing. No preemption. Oil and gas operations in the business or residential area prohibited or restricted. That's permissible as a police power mechanism, but that must be reasonable. But for our purposes, that's just the beginning of the analysis. Whether the initiative passed under the auspices of police power is preempted by state law or federal law, and we respectfully submit that that's what is the case here. The Friel case, again, both the intervener and county cite that. Same thing, not a preemption case, prohibited oil, gas operations in residential areas, and the court made clear that it did have to meet the arbitrary oppressiveness and unreasonableness standard. So the key case, I think, of all these that has been cited is the Higgins case. That's the California Supreme Court. It's one of the more recent in this line of cases, 1964. The only case to talk about preemption. And the court didn't deal with the broader jurisdiction-wide prohibition in that case. It narrowly ruled that the city of Santa Monica could kind of go back on a lease and because of its police power. And the Supreme Court held that that was permissible under the police power, that it could ban oil production even if it would have an effect on an existing lease that had been entered. But the key here is that it said that the mode and manner in which the city may execute oil leases on city-owned lands, that is preempted. There were statutes that said exactly what a city had to do and had to put it up, I think sort of a public comment, had to be very transparent, that law did preempt. This was the mode and manner. And that's what we have here. Measure Z seeks to regulate not whether oil production can occur. Measure Z does not purport to ban oil production. It's very explicitly and in practical effect regulating the mode and manner of oil production. It says you can't do well stimulation. You can't inject produced water back into the ground for storage or disposal. You can't drill new wells, even if that's crucial to your injection program and to fostering the steam chest, which is crucial to getting out the oil. So this case, Measure Z, is all about the mode and manner, and that's preempted. The California Supreme Court in the Big Creek Lumber case focused in on this distinction. In Big Creek Lumber, Your Honor, the issue was whether a local regulation that precluded timber harvesting in a particular area was preempted by a comprehensive scheme regarding how lumber operations were to be conducted. And the California Supreme Court found there was no preemption because the regulation only regulated where the activity could take place. And the court said, in order to avoid speaking to how timber operations may be conducted, and it addresses only where they may take place, fall short of a clear attempt to regulate the conduct thereof. And here, what could be clearer than that Measure Z is regulating subsurface activities and how Chevron and Aera and other companies can engage in oil production activities. That's exactly, they're saying, here's how you have to do it. You can't do these things. Maybe we'll let you do these things. That is preempted. In the Desert Turf Club case, was a local regulation about horse racing that really seemed to ban horse racing within the locality. And the Court of Appeals said, state law authorizes this, and you can't, under the guise of doing one thing, accomplish a wholly disparate end and forbid what the state expressly permits. You can't do indirectly what you can't do directly. That's what Measure Z is doing. It's calling it land use, but it's really banning well stimulation, which the state encourages, banning underground injection for purposes of heating the oil and the like, which Section 3106 encourages, permits, makes the policy of the state, and banning the drilling of new wells when that's integral to everything that goes on at San Ardo Field and it's underground. And with that, Your Honor, really the last issue I had, that I wanted to cover in this part of my presentation is severability, because I know the court asked about that. The legal standard is straightforward. The test is whether it can be said whether the electorate's attention was sufficiently focused on the parts to be severed so that it was separately considered and adopted them in the absence of the invalid provisions. And here, we think this is all, we strongly submit that Measure Z was all part of a package. The anti-fracking portion was what I think was the main focus of Measure Z and the campaign and the language. The other part of it, the other formulation of the test is that if you go to the next slide with the Birkenfeld case, is it clear, I'm rephrasing this a bit, but can we say that it's clear that the electorate would have approved the measure if the board had been given broader rental adjustment powers? That was the rent control case. So that was the last remaining provision there that was going to be upheld. I just don't think we can settle this. Measure Z, it was marketed as this anti-fracking provision, a hot button issue, and it passed. And Everything else was pulled along with that. If any part of it is struck down, or if the court orders the county to vacate portions, then the entire measure should be vacated. And we looked at, and we talked about in our papers some of the ballot material. I know the court's questioning how much this should be considered, but I think on the severability it's really important because we need to look at what the voters were presented with. So this next slide, we have it was ban fracking, protect our water. Those really the first two provisions of Measure Z were emphasized. In addition, the emphasis was on fracking, acidizing, and wastewater injection, which I think is next slide. Wasn't on new wells. In fact, the preserves our current oil job and county tax revenue. The proponents of Measure Z were really walking a fine line. They wanted the voters to understand that things weren't going to change going forward, but other processes were being restricted. So we believe, Your Honor, it's all integrally related. As I said, the new wells and the underground injection processes are closely related, integral to each other, and therefore we don't believe that any provision of this is severable. And going back, just to finish on the standing point, I read you the part about the new, the Measure Z saying this could change new technology. The whole idea was that voters needed to vote to ban well stimulation, including fracking. And these other provisions were included in that, which are directly in the zone of DOGGR, just like well stimulation. So it would be, I think, contrary to the intent of the voters and incorrect to say that any part of that Measure Z can survive if the court agrees with this, that any part is preempted.
So, if otherwise valid, the fracking ban could stand on its own.
Your Honor, I think that if you we think it's preempted, but if the other two provisions were struck down, then there would be an argument that that was the lead provision. I think it's clearly preempted. I know we have the standing issue there, but that's the only one that has a fighting chance to be severed because that was the lead provision. But the other two were along for the ride. They're preempted. All three are preempted, and we would request that the court make that finding and order the county to vacate Measure Z. Thank you very much.
Thank you. All right.
We've decided the shortest presentations to go next, and I'm just going to say I intend to join on behalf of CRC the arguments made by Chevron and the other council. Obviously reserve the right to, in the rebuttal phase, to make some comments. Thank you.
Good morning, Your Honor. My name is Andrew Bassick, and I represent Aera Energy, along with its 1,100 employees statewide in California, and its hundreds and if not thousands of contractors. Having had the waterfront covered very well by Mr. Boutros, I only have a couple of comments I want to do to follow, and I'll talk a little bit about something that you mentioned early on in this case, but I think it's important from the petitioner's point of view to talk a little bit about what isn't going to be decided in this case. I want to talk a little bit about an argument that the defendants and interveners, defendant interveners in the county are making that there is a presumption against preemption that is not present here. And then finally, I want to do a little bit more of a deep dive into the severability issue, given the importance of that. So first, with respect to what is not at issue in this case, and you touched on this earlier, we're all aware of the vigorous public debate about the relative benefits of hydraulic fracturing to enhance domestic oil recovery. In arguing in this case, we're not going to resolve those issues. And those differences of opinion really don't play a role here. The first issue in this case is whether or not the superior laws of the state of California, the superior laws of the United States government, preempt Measure Z and render it void. Similarly, we're not here to continue the debate about the referendum on Measure Z. The election is over, and the fact that this ordinance came into existence by virtue of being a voter initiative has no bearing whatsoever on the issues before the court. In fact, from one point of view, the voters' will be validated regardless of the outcome. It's just a question of whether it's the voters of the state or the voters of the county, because the laws of the state of California are authorized by the representatives of those voters. So to say that the voters' will is somehow at issue here is not true. Second, on the issue of the burden of proof for preemption, what the petitioners need to do and what we have done is demonstrate that Measure Z is preempted by superior law. And I think Mr. Boutros laid out an excellent case for that. In the opposition briefing, we've seen arguments, however, where there's an attempt to create a heightened burden that is in the form of a presumption against preemption. That some cases have in terms of where there is an area that has been traditionally regulated locally. And this goes directly to the use of land use jargon to create an appearance of land use language in regulating subsurface oil and gas methods of extraction and operations. And it's important here because that presumption does exist in the law, the presumption against preemption, but only when you have an area that has traditionally been within the ambit of local regulation. It certainly can't be the case that Measure Z can use the phrase land uses in support of and then go off into a discussion of the technical operation of an oil field, what type of acid, acidization might be able to be used, what type of fracking, et cetera, et cetera. That doesn't render it land use. So because the area of oil and gas regulation needs to be uniform statewide and in fact in some areas nationally, and because of the statewide policy in favor, it can't be an area of traditional local regulation, and therefore that preemption, the presumption against preemption simply doesn't apply. And even if for some reason you had some concern that it might be, that preemption only applies in the area of field preemption, not in the area of conflict preemption. Mr. Boutros made an excellent argument as to why the field is preempted, but if we move beyond that analysis and look only at conflict preemption, the presumption wouldn't even come into question because it's not part of that analysis. All right, and thankfully I get to do this part right before lunch because this gets a little bit technical, but I want to talk about some of the granular detail of the severability analysis. Measure Z is not severable. The three parts are together and will stand or fall, as one. Mr. Boutros reviewed the rule that in order for an ordinance to be severable, there needs to be a severability clause in the first instance. when there is a severability clause in the language of the statute, the analysis doesn't end there. That's the threshold question of whether you can discuss severability. If an ordinance contains a severability clause, an invalid provision can be severable only if it is grammatically, functionally, and volitionally separable. By words, by how it works, and what the voters thought they were voting for, or what those three phrases mean. And unless it meets that test, it needs to stand or fall as a whole. And in fact, Measure Z is not grammatically, functionally, and mechanically severable, or volitionally severable. This goes back to the grammatical test. We'll get to that in a second. But because in fact it was designed not to be severable grammatically, severable functionally, and severable volitionally. And I'll walk you through that. And what I'm going to do is I'm going to talk a little bit more about the law, but then I want to show you some examples. And I'm going to show you that the text of Measure Z itself says that despite having that severability clause, that it is to be considered as a whole and must be considered as a whole. So again, on the grammatically and functionally separable issue, the language of the statute has to be mechanically severable. That is, where the valid and invalid parts can be separated by paragraph, sentence, clause, phrase, or single words. For instance, an attorney's fees provision that is simply stricken and taken out of the statute, or some other subsection that falls away and the rest stands on its own. When we get into the details of how Measure Z was constructed, that's not possible. Let's go to the next one. Functional severability. So, in order to be functionally severable, after this severed portion is removed, the rest of the ordinance must stand on its own, unaided by the invalid portions, nor rendered vague by their absence, nor inextricably connected to them by their policy considerations. Next. So let's take a look at the implementing provisions, mechanical provisions that put this into effect. These are in Section 7, and they are, some might look at these as boilerplate. They have legal import. They have meaning. They're part of what the voters passed. So 7B says, upon the effective date of the initiative, the provisions of Section 2 are hereby inserted into the Monterey County General Plan. Section 2 is all three legs of Measure Z, but to be inserted into the general plan. No fracking, no reinjection, no new wells. Section 7C says, following the effective date of this initiative, the County of Monterey is hereby authorized and directed to submit the amendments to the Coastal Land Use Plan. All of them together. If the underlying provision, some portion of it, was attempted to be severed, these provisions make no sense. Again, the third piece, the four-door master plan amendment, same problem. All three portions are in there, and they are to be submitted together to amend that plan. That no longer makes any sense if any portion of that language, of the underlying operative language, is removed. So why was this done this way? We may have some more examples. Let's go to the next slide. So even the sections 2, 3, and 4, the sections that relate to the amendment mechanically of the general plan, the coastal land use plan, the four-door master plan, that's 2, 3, and 4, shall remain in the general plan despite any other subsequent amendments. So, reading this language, it's not possible to isolate no fracking portion of this. It's together. It's meant to be one. Let's go to the next slide. I think this is our final example. Again, this is no initiative, no rule shall be enacted, no inaction shall happen that is inconsistent with the initiative in its entirety. Not in this initiative or any portion thereof. It is the entire initiative. And again, this is grammatically very granular, and I apologize for that, but words matter. And what this says is that it's the entire initiative, not a portion thereof. Next slide. So why is it this way? Well, Measure Z actually tells us why it's this way. Because Section 8 of Measure Z says that the initiative adopts a comprehensive scheme, meaning that the three legs are to work together and are intertwined, prohibiting land uses in support of well stimulation treatments and oil and gas wastewater injection or impoundment and the drilling of new oils and gas wells within the county's unincorporated areas. You can't sever any of this. It's all together in a comprehensive scheme, and because we believe all of it is preempted, but even if one leg of Measure Z is preempted, the entirety of it is preempted. Furthermore, the voters expressly declared their intent, and this is language that was in connection with the risk of a competing ballot initiative, to say that if there's any conflict with another ballot initiative, then it's deemed to conflict with the entire cohesive scheme adopted by this initiative. That works the same if it's conflicting with any state or federal law. And so if there's a conflict with a part, there's a conflict with the whole. And there won't be any severability. So that's grammatical and functional severability. Let's talk a little bit about volitional severability. The next slide. And this Mr. Boutros touched upon briefly. So the test for volitional severability is whether it can be said with confidence that the electorate's attention was sufficiently focused upon the parts to be severed so that it, the electorate, would have separately considered and adopted them in the absence of the invalid portions. Now, I'll wait to hear the presentation from the county and the interveners. There is no evidence so far in the record for the defendant or the interveners to meet their evidentiary burden. In fact, any evidence at all that they can use to demonstrate with confidence that the voters focused on any particular part of the initiative and would have passed it alone. Instead, because nothing of that sort exists, they attempt to reframe the question, not as to whether they were sufficiently focused upon the parts to be severed, such that they would have adopted them in absence of the invalid portions, to a question of whether they were simply informed about the three prongs and that there were three prongs. That's far short of their burden. They need to show that one or the other or all three would have been passed separately with competent evidence, Your Honor. And there's simply nothing in the record to make that point. And again, the reason they can't do that, switching to the last slide, it is that the initiative, by its own terms, by Section 8, is a comprehensive scheme. It's designed to work as a unified whole. I think I think it was referred to as cleverly prepared or something like that. Maybe too clever by half. And it is a comprehensive scheme and must stand or fall as an entire. That's all I have with Mr. Boutros's presentation, with which I join on behalf of Aera Energy.
All right, thank you. Well, rather than start somewhere and interrupt, we'll just take a new recess at this time. We will resume at 1:30, but the public doors will be open ahead of time so people can come in and see this and start. See everybody.